Good evening, everybody. Hope everybody is safe. The team at Create and Product IP wishes you a very happy Diwali. And we would like to take a second and thank you all for joining us today. We really appreciate it. And as a token of, this appreciation, we would be giving a little takeaway at the end of this webinar. So stay tuned for the same. Let's start. I think everybody is here. So let's start by introducing us. We are the co-founders of Create and Protect Intellectual Property. This is my very talented colleague Shravani, and I'm Yesheshvini, and we would be teaching you about copyrights today. So copyrights is also known as the creator's right, and the roadmap to this webinar would be something like this. What we'd be doing is we'd be dealing with the basic part of copyright, and then we'd be dealing with the practical aspects. So the first half of the presentation I'd be dealing with, and then Shravani would take over. Now let's start with first defining what is copyright. Obviously, it's a type of intellectual property rights. To explain it a little better, it is a right under law for creators of different kinds of works, like mentioned. So it could be literary, it could be dramatic, it could be musical, artistic, cinematographic, or sound recording, right? And copyright in itself is a bundle of rights. So for example, if I am writing a book and I have a copyright for this book, I will have the bundle of rights with respect to reproduction, communication to public, adaptation, and translation of such work. So what happens is this bundle of rights also varies from, let's say, work to work. So it would depend on the kind of work you have registered. To recap this entire slide, let's just say that copyright is a bundle of rights given to creators under law for different kinds of works. It's as easy as that. Um, Going to the scope. So now that we know what copyrights is exactly, let's talk about the scope of copyrights, right? So we know what the right is. When it comes to copyright, it has to be original work. So anything existing in the market cannot be copyrighted. It has to be something original, and for the fact that has to be, it should be your creation. It should be the first creation, should be your creation. Now, if people who do know a little bit about copyright would know about the fact that copyright exists from the day you have created something, right? So it's something that happens the moment you start creating something and have it in a medium, let's say on your laptop or computer, and versus the you going and registering it. So coming back to the example of me writing a book, the day I finish that book, or let's say the day I start writing it, I have a copyright as long as it's original work, it's an original story, and it's something very, different from what's existent in the market. I will have copyright, but the fact that, a stronger fence of protection would only be available to me if I register it as a copyright under literary works. That I'll explain you later how it comes under literary works. But again, the entire concept of registration revolves around the fact that you will have a stronger fence of protection over people who are going to copy your work or people who might try to adapt it. What does not come into the ambit of copyright. So when we talk about copyright, there are specific kinds of works that come into copyright. So if, let's say, your work is not under these categories, it would be difficult to register it as a copyright. And when I say the kind of works, I'd be dealing with that in the next slide. But for you to know what does not come into the ambit is a kind of idea, a method, or let's say a slogan. Things like these, like a idea per se or a concept per se, cannot be copyrighted. It has to be under these works, which we'll be learning about in the next slide. Now, coming to what is work, I have mentioned work a lot of times without defining it, so I'm just going to go ahead and define it. Work is the final product or the creation of a creator. Like, let's say, coming back to the example that I am writing a book, the book in its entirety, once I've written it and once it's done, that would be my work, and it will come into a particular category which would be discussed in the next slide. um, the fact that I have a copyright, obviously the right has to exist for a particular period of time, right? So when we talk about term of copyright, it is 60 years, and it also it starts from the day that you've registered it or started producing it per se. Let's deal with The kinds of work. The kinds of work have been listed in this slide. What I'm going to do is I'm going to go ahead and make sure that you guys know each and every work through examples. So let's not try and define it per se, because again the ambit is open, but let's try and use examples to make sure you understand. The first one is literary work. As the word suggests, literary work could be anything from lyrics to research papers to, let's say, business proposal, databases, software codes, and books. So the book I was writing would come under literary work, right? Um, Literary work is something, let's just say it's an proper way of denoting things down in a manner that you understand that what is happening. It's a proper, so a book, it would be a literary work because it has a storyline, it has things going on there. That then research papers, even books of competitive exams today, poems, and all of these things are registered as copyrights. When we talk about the second kind of work, the dramatic work, it is very similar to literary work. The only difference would be the reciting this work, putting it in a format, in an arrangement. So any kind of dance choreography specific to, let's say, a group, or any kind of arrangement of a play. So let's say there is a play in place and there is certain arrangement that happens, that would be dramatic work. The third category would be musical work. When we talk about musical work, it's obviously related to music, but what's different here is lyrics are not a part of musical work. Lyrics are part of literary work. Music is graphical notation of such, the music chords you're using, the kind of music you're using. So it's proper graphical notation of the music you are creating. That would come under the ambit of music work. Coming to the most important and I think the most used category when it comes to copyright is artistic work. So artistic work is again a result of artistic craftsmanship, right? So it could be a painting, it could be a photograph, it could be, let's say, sculpture, a plan, or anything relating which is like depicted in a manner would be artistic work. Something we have to be careful when it comes to artistic work is it may or may not possess artistic quality. So for example, the criteria to have an artistic work is not the fact that it has to look amazing or it has to have artistic quality. As long as it is a work of artistic craftsmanship, it would be artistic work. Now it would differ from me to you. I could have a different drawing or abstract drawing than what you have. So that's the difference here. It is not it's not taken on the artistic quality of it. Cinematographic work. When we talk about cinematographic work, it's basically a visual recording with a moving image and a surrounding sound to it. So obviously our movies, our OTT series, and even video games come in this aspect. So if we take an example, let's say Road Rash. So games like Road Rash do have something going on, some sound going on in the background, the bike is moving, there is a background of, let's say, a road, gardens, whatever. So the map and the kind of background you have, all of these accompanied in a medium, recorded and accompanied in the medium, would be cinematographic work. Sound recording, as obvious as its name, would be different kinds of sounds recorded in a medium and put together to be registered as a copyright. I don't know how many people knew here, but this is an interesting fact. Where codes, annual reports, business proposals, a lot of things do come under copyright. It's just the matter of fitting it in a particular category. So you do have to make sure that you are able to understand the category of work you are coming in. So it could be literary, it could be musical. Now, for example, a song, it cannot be a musical work per se. The music part of it would be the musical work. The lyrics would be literary work. So that is how you differentiate when you go and register a copyright. Reasons for copyright protection. So now that we have the scope cleared out and now that we know that how things are going to be, why is copyright protection important in a society? So first of all, copyright safeguards creation and it protects and rewards creativity. So if I as a author know that my book is protected from kind of copying, it would encourage me to probably write more books. And why is creativity so important for a society is because it is the keystone, it's the cornerstone of a progressive society. You cannot have a progressive society without constant changes in the kind of technology, in the kind of artistic work, in the kind of things you are using, right? That is what its social and economic development is about. You cannot have the same kinds of softwares from back, let's say 10 years back, or let's say the same kind of things happening for a country or a society to progress. Now, why protection for copyrights? Obviously, creativity getting protected is well and good, but protecting it in terms of copyright would be to have an encouraging environment for creators. Because if we look into categories, these are the people who are the genuine, real creators of the society. These people create a lot of things which probably go unnoticed by us, and it's that easy to copy anything today. So instead of making sure that there's less copying as well as there's protection, it will help people to get into this field more, and encourage an environment where people do create a lot of new things. And obviously it'll lead to less copying of work. When we talk about infringement, which is again an interesting fact for you guys, infringement is obviously unauthorized use of your copyright. But did you know that it varies from case to case? So when we say, let's say if somebody copies something from my book and somebody copies something from Shravani's painting, it has to be something very substantial to my entire copyright. And when I say substantial, I do not mean quantity, I mean quality. So if my plot twist or my main story character is copied and put into, let's say, a movie or a series, that would be substantial infringement. He does not have to follow the same line of thought. He just has to pick up something which is like very substantial to my protection. So that's one thing when we talk about infringement. um, Examples in case laws. Now that we know the kind of thing copyright is and the kind of protection it gives, the scope and everything, I would like to address a couple of examples, real life examples, things we see, because I have heard this a lot that not a lot of people take copyright seriously and not a lot of people do it. So I was like, why not go ahead and show you a couple of these examples. So let's say the first example, I don't know how many of you are aware of it, but this is an episode from Madeline series. It's an animated show, and the episode is it's in a wedding. The format of the episode is a wedding, so it's a wedding created script, and that is what the entire script of this episode is copyrighted by the series. So the producers of the series have copyrighted this entire episode. The famous cartoon Tom and Jerry we all grew up seeing, that is also copyrighted in an artistic work. Now, the third one's an interesting one, the gifting policy of Tata Steel. Obviously, it sounds a little, why gifting policy? But probably it's because it's unique to them. They have gone ahead and registered it as a copyright under literary work. Then the signature tune of, let's say, Tata Capital. I'm sure everybody has seen that advertisement, and the tune per se is registered as a copyright. Ganesh sculptures, for that matter, not the exact Ganesh sculptures, but Ganesh sculptures, let's say Ganesha reading, writing, or maybe in formats which weren't explored before this, have been registered as copyright. And the biggest industry in India right now, Reliance, the logo has been registered under copyright in artistic format. So that's about it. I would like to take a minute and divert this conversation and bring up the fact that, what we do in an organization, because we also really support the fact that brand protection and brand awareness go hand in hand. So as an organization, the primary agenda that Create and Protect IP Partners has is, making sure that the landscape of IP in India is progressive, it is more aware, and it reaches a level where intellectual property is taken seriously and is accounted for. It's not treated as an expense, it is treated as a long-term investment. And to cater to that agenda, what we do is we make sure we provide legal help to all kinds of industries and all kinds of companies. It's not just large scale or small scale companies. We cater to startups, we cater to inventors, we cater to individual creators. We make sure we understand the kind of market and the kind of it's the work that the market requires when it comes to intellectual property. So that is something we do. And shifting back to the case laws, now that we've talked about what we do, would be so these are the three case laws I've mentioned, is basically because, let's say, my book which I wrote, somebody infringed it, A infringed it. What happens in court? How is there compensation? Is there, let's say, a relief to me? What happens exactly? So the first case is an interesting one. The first case deals with the overlap of the Design and Copyright Act protection. Again, another very well debated topic. What happens is both of the protections cannot exist at once. So if you have a Design Act protection, you cannot go ahead and claim something in the copyright, have a copyright claim against it as well, saying that, my copyright has also been infringed. There just can be two kinds of, one kind of protection existing between the two. The legislative intent was also, the courts kind of quoted it, saying that the protection for commercial use of things is a little bit lesser than the protection for pure art and for pure work and, artistic kind of work, pure art. So what was, narrowed down, that the fact that, you can just have one kind of protection when it comes to copyright and or design, and if you do not have a protection under design, you can obviously go ahead and have a protection under copyright, only with a threshold limit which is like 50 times. So if my book has been produced more than 50 times, that is my threshold limit to have a copyright protection. So that's about it. For Microsoft Corporation, the case dealt with the very infamous activity that's happening around everywhere, software piracy. So what the defendants were doing, they were selling the softwares without any proper license with the same kind of packaging, and that's why Microsoft went ahead and called them out on it in court. So that the defendants claim that nothing like this, we have proper licenses, and the court intervened with an investigation which led to the court finding out that they did not have proper licenses, they were selling pirated versions, and they were kind of copying the same kind of packaging Microsoft has. So the court went ahead and granted a permanent injunction as well as a monetary compensation for Microsoft, saying that whatever was done here was wrong. It damaged Microsoft's reputation and also damaged the kind of intellectual property rights they have over this software. Dealing with the third case, this would be the case where there were two scripts here. So the plaintiff had a script which dealt with clinical trials, and the defendant had a movie which he made which was also dealing with clinical trials. So the plaintiff went ahead and said, it's something very similar to what I have done. This was a Bombay High Court case. The court went ahead and saw both these movies, and they kind of found out that the only similarity is the storyline of the script. So both the scripts dealt with clinical trials, but not both of them had the same narrative or the same kind of preparation towards the storyline. So the court did point out differences to the plaintiff, and the plaintiff agreed to it, that maybe that is what the differences are. The main idea, the opinion that court gave was that an idea can have several forms of expression. You and me can write a similar book on a similar rhyme, but it could be completely different. And the idea of having a script of clinical trials is not, there's no monopoly in the market saying only I can write clinical trial scripts or have movies or plays on it, right? So the court said that because it's in the public domain and he's just made a movie which has a different kind of agenda to it, does not mean it's copying. So that's one thing we do take away from this the three cases, is that the court does consider intellectual property rights for one. Two, if you do want to, you cannot copy something from its very substantial, the kind of substantial material they have in a particular art form or let's say work. You cannot copy it just by saying that it's similar, it's it's something, we are doing this, we are doing that. That does not work. You need to ensure that if you are taking even inspiration from somebody, it has to be something very basic and in public domain, rather than building up, taking my entire book and copying. You probably can take the storyline. Let's say my book is based on clinical trials. Somebody writes a book on clinical trials. It won't be the same thing. It cannot be the same thing. That is where I can go in court and challenge his or her book. So that's about it from my side. Shravani will now take over.
Yes. Now that we have a really good base covered by whatever Yesheshvini has dealt with, the basics of copyright, the scope of protection, and the kinds of work that are involved, also why it is important to register your copyright, I will be dealing with the practical aspects in copyright, which will be fair dealing, which is the exceptions and limitations under copyright. Then I'll go ahead and talk about the Creative Commons license, which is a great platform for creators, and lastly I'll go ahead and talk about the registration process of the copyright. Now, moving on to the fair use and fair dealing, this is one of the most important exceptions in copyright, which basically gives you the right to copy. Now, copyright, as we know, that if Yashwini has a work that she has registered, I cannot take that work. But there are certain limitations and exceptions where I can have the right to copy without actually taking a permission from Yashashvini firsthand. So this is what we will be dealing with here. Now, fair use is known as fair use in a lot of other countries around the world, but in India specifically, it's called fair dealing. So that's what I'll be dealing with today. So, Section 52 of the Copyrights Act talks about fair dealing. It doesn't actually define what fair dealing is, it doesn't say it in words, but it tells what that legal doctrine is. And what that legal doctrine is that it allows a person to make limited or transformative use of a copyrighted work without the permission of that owner. And that is where we come and we understand why it is important without the permission of the owner. There's a very thin line when it comes to fair dealing and infringement, and that's why we want to know, okay, what constitutes as fair dealing and what will go ahead and cross over and be known as infringement. So copyright laws in India as such are not as advanced as they are in most of the countries outside. But so that's the reason why we don't have like proper set guidelines in India which tells us what is fair dealing and what is infringement. We don't have set say number of passages or words or prose that I can actually take from her and will constitute as fair dealing or will constitute as infringement. And that's why we have the four main factors which are usually considered when it comes to fair dealing. And those four factors over here are the purpose of the use, the nature of the work, the amount of the work used, and the effect of that use on my original artwork. I will talk about this later when I come to an example, but these are the main four factors based on which you have to determine whether a work that I've taken from somewhere is fair dealing or is it unfair dealing and infringement. Now, when is fair dealing actually permitted? Now, these are the 4-5 pointers when your fair dealing is actually you can take that work from somewhere. So these are research or private study, which means that if I have to say write a case note or if I have to write a research paper and I find something which is very good online, and then I can take that and I use that as my study, as my private study. That's where I can do the research and study. Criticism or review, when you see film reviews or even sports reviews, they take a clip from the sports, from the game or that film or that show. They take a clip from there and they show you. They either criticize it or they review it. So that's where fair dealing is also applicable and understood. Reporting current events, which will be say news, newspapers, magazines, all of these places are also safe from copyright infringement. You can take material. For judicial proceedings, in court proceedings, if I have to prove something, then I can use that and like say it verbatim in the court, and that will still be okay. It won't be infringement. And then last would be performance in front of a non-paying audience, which is even like right now, this webinar is like a non-paying, it's a free webinar. Whatever we put down over here, if we have taken it from anywhere, that would be fair dealing. That would not be infringement because we're not gaining any profit out of it and we are not infringing someone's right. So these are the main pointers where fair dealing is actually permitted. Now I'll give like a small example so that this concept of fair dealing will be slightly clear. So for example, now I'm an artist and I have a painting that I draw, I draw a painting of say sunflowers. I have 10 sunflowers in that painting and they're positioned in a certain manner. They have some grass, some leaves on the side. There is a sun rays are dropping by, and there's a particular color of yellow and a particular shade of green that I'm using in this drawing. That is my artwork. I will go ahead and sell this artwork, and I will try and, I'll probably gain profit out of it. It'll be great. I'll go ahead and show this in the art galleries and all of these places where it's out in public to see and it's out in the public to display. Now, see, if one of you kind of comes and sees this art and gets inspired by it, they want to create something of their own by looking at this little artwork of mine. What you do is you go ahead and make an artwork which will have, say, 8 sunflowers. It'll be positioned in a similar manner, if not the exact same manner. It has a sun, it has the rays. And now if I put both of those drawings side by side, what I'll see is there's substantial amount of copying. Like, it's almost the similar drawing artwork as mine. And what you do is you go ahead and sell that at a lower cost outside, at a lower price outside, and you get profit out of it. And that's where the fair dealing line has crossed over to infringement. And that's why we go ahead and see these 4 factors and consider these 4 factors. Now, when the purpose of the work is mentioned over here, the purpose is both of us have the purpose of getting profit from this artwork. We are selling this artwork and we're getting profit of it. The nature of the work, both of us have put it down in an artistic format. It's a painting that we've put it down in. The amount of work used, 10 sunflowers, 8 sunflowers, positioned in a similar manner. There's a sun and the rays. It's kind of the same thing. It's quite similar. So amount of work used is almost the same. And the effect of the use of the original. Now, since you are selling it at a lower rate than I am, you are getting more profit, and it's affecting my design and it's affecting my profits. And that's where you have crossed the line to infringement and not under the ambit of fair dealing anymore. So these are the main things that you need to understand when a work is fair dealing and when it moves on to infringement. Now, these 2 cases that I've mentioned here are like the the foundations of fair dealing, I can say. And the first one being the Kartar Singh case. Now, in this that they have mentioned is fair use of amounts to infringement if the copy of the work affects the original. The fair dealing must not lead to competition, and they laid down 2 main pointers. I will actually read it out from the judgment what the pointers were laid down. They said that in order to contribute unfairness, there must be an intention to compete and to derive profit from such a competition. And the second pointer was, unless the motive of the infringer were unfair in the sense of being improper, the dealing would be fair. So the main thing that this judgment was telling us is that the motive or the intention of that infringer is something that needs to be taken into consideration. If you did that and you did not have an intention, if you were completely unaware of my artwork and you had your own artwork and you made that and sold it and your intention was fair, it wasn't improper, it wasn't unfair, you did not want to just get profit out of it or have competition with me, then that would be fair dealing. So it just depends from one case to another. There's no set guidelines, so it depends on one case to the other. The next case is the University of Oxford case, which is also a very interesting case. This case was basically held in Delhi. So there was a photocopy shop in the university, in the campus of University of Delhi, and what they did was they took some material from the prescribed textbooks of that university. They took that material, they took out photocopies of those material, and then they sold it to the students at a subsidized rates. And the people students on the campus obviously bought those copies because they were at a subsidized rates. University authorities, when they got to know about this, they went ahead and they filed a complaint against them and asked them to shut the shop. But what the court held in this case was really very interesting actually, is that the court said that since this was done only for the purposes of education and to spread knowledge, it will not amount to infringement. It will still come under the ambit of fair dealing. Another very important thing that was done from the photocopy owner, the person who owned the photocopy shop, was that he had a reprographic license. Now, what a reprographic license is, reprography is a form of reproduction or duplication of literary work usually carried out by one of the followings, which is printing, photocopying, scanning, any of these things. So what it does is he had that license, and because of that license he could take that material from the university and actually go ahead and sell this. So this reprographic license is one of the very important licenses, especially if you're a student, if you're a research scholar, an academic institute, all of these people, it's very important to have that license, because some of the advantages of this license are that you can not only access material which is in your domestic, that is in India, you can also go and access global publications and take some material from there. It will obviously lower down your copyright infringement costs, or if anyone goes and files a complaint against you, you obviously have a reprographic license to show and say that, okay, I have the right to do this. And then lastly, you don't have to necessarily take permission from the actual and original owner of that author or the copyright owner. And that's why it's very important, if you have a reprographic license, you should make use of it and then accordingly use it, and still be under the ambit of fair dealing, not cross it to infringement even there. Now next we will be talking about Creative Commons. Now Creative Commons is a non-profit organization. It's a global organization actually, and what they do is it becomes a platform for a lot of creators to put their work on public, and they will give out free licenses for that work, for that creator's work. And that is what Creative Commons is. For Creative Commons to work, there are different methods to do it. You can obviously go on their website and put your work over there and have the terms and conditions for your license, or there's also this way to do it. So on Google, if you see, I'm not sure if you are aware of it, Google had usage rights for the Google images that you go and search for them. Now these were the old usage rights that were in Google. When you would type out anything and you want to put it in your, say, blog or any other place that you would like to use this image, these were the kind of usage rights that were given by Google before. Now in 2020, these are the new usage rights that have come out with Google, that are these three main licenses. One is all, the other is Creative Commons license, and the commercial and other license. I will quickly jump out and show you guys actually how to do it and how to work it, so that it will be great and it will be beneficial if you have to use it in any of your future work. So I've come on to Google. I'm just going to type daffodils over here and go on to images. Under images, you will find this little tool over here, which you press that and you will see that there's usage rights mentioned over here. Over here, I'll go and see the Creative Commons license. Now, Creative Commons license is used when you are using the work for your blog or for educational purposes, for purposes which do not give you profit. That's when you use the Creative Commons license. Now, when you see all of these images, you will see that on the left-hand side corner, there's a badge which says licensable. I'll just click this image and I'll see that here you have the license details for this particular image. We'll click on this, and this is what the owner and the author of that particular image has given me. This is a license that person has given me. I am free to share and adapt this particular image, and there are a few terms that have been mentioned over here that you have to keep in mind whenever you are using that image further, whenever you are using it. So that is the Creative Commons license when it comes to work that does not give you profit. But now when you're using that work for profit, if you're selling that artwork or anything after that, then there is a different kind of license that is required, which when you drop down over here, you'll find there's the commercial and other licenses. Let's click on that and you'll see again a set of images different from the first set of images, and everyone again has this little badge called the licensable badge. I'll click on this again, and here let's see there's a Getty Images, there's the name of the photographer is also mentioned, and again there will be license details mentioned here. I'm going to click on these license details, and this is what the entire licensing agreement has come. This is because I'll be using it for commercial purposes. I need to know how to rightly use that image, how to rightly take that and incorporate it in my artwork or in my any kind of work that I'll be producing from here. And that's what you have to make sure whenever you're doing this, whenever you're taking any Google image, you can't just take it as it is. You'll have to just go ahead and see what is the purpose of your work, and accordingly choose the license and go and check the license details. That will just give you a full rounded protection, and it will just help you from any future infringement actions that might come from the original owner of this image. Going back to the webinar. So that is the Creative Commons license, and those are the details that have been mentioned by the Creative Commons. Now lastly, I'll move on to the registration process. Now registration process obviously is very, very important. We all know that copyright registration has to be done. Yesheshvini has very nicely explained it in the previous part of the webinar, and I'll just go ahead and tell you guys how to do the registration. What is the process of registration for a copyright? Now these are the few questions that usually are what we get whenever a new client comes. Anyone who is new in this field and does not know much about copyright, these are the few questions that we are asked usually. Now, who can file? The original and the first author and owner of that work is someone who can actually file for the copyright. Now, when it comes to say sound recording or the sound recording, it will be the composer who is the author. If it's a cinematograph film, or if it's a cinematograph film, will have the producer as the owner or the author of that work. If it's a photograph, then the photographer will be the actual author of that work, and he's the one who's going to be filing this for them. Obviously, if you have a legal representative as a lawyer who is going to file for you, then you just have to give that person the power of attorney, but the main author of the work still remains you, who has created that work. Where is the application submitted? Now in India, we have the Copyright Office in New Delhi, and all the applications that are made are directly submitted over there. Now, even if I am right now sitting in Maharashtra, for example, if I make a copyright application, it will directly go to the Delhi office and will be scrutinized there by the Registrar of Copyrights. Then there is domestic or international protection. These are two, but like any other intellectual property that we have, copyright is a territorial right. So for me to get protection internationally, I have to first go ahead and get protection in my own country. So for that matter, you have to go and first get a protection for India, and then you can go ahead and get multiple protections in other countries through Berne Convention, which we won't be talking about right now, but you can have both kinds of protection. Then lastly, the fees. For all kinds of different kinds of works, there's different kinds of fees that are available. For literary, dramatic, musical or artistic work, the fees is going to be 500. Cinematograph film is 5,000. Sound recording is 2,000. Now, if I have 2 articles that I've written and I want to get those copyrighted, they will be 2 separate applications. There is nothing like a multi-application in copyright. So every little work, everything, even if it's a 2-word poem, you have to get a single different application for each work. And that's how the copyright applications work. So I'm going to go ahead and show you how the interface of copyright application looks like. This is the main page of copyright application. You can just go ahead and make an account. Anyone can go ahead and make an account on this website. And this is the landing page of the website. We'll go ahead and check the e-filing. I'll just have to log in once again.
While she logins, we are checking the live chat, and there are a lot of questions. We would be addressing that in a couple of minutes and making sure whatever you've asked is answered.
Yes. Yeah. So this is the main landing page of the copyright government of India office, and this is where you go for a new applications. On this left hand side, you'll see the e-filing of application, and this is where your main page is. It will give you all of the details that you need for the application right over here. So it's not a very difficult application. It's just there are a few steps that you have to actually take. Then from here, we'll go ahead and click on the application. Now since we don't actually have a new application that we have to register, I'm going to tell you guys how it is, and if you have any questions, you can obviously reach out to us anytime. And so this is the main page. This is the first form that you have to fill. Form 14 is the main form for your copyright application. The step 1 is your normal address, applicant's address, normal details. Step 2 is statement of particulars, which will ask you the proper details of the applicants. Who is it? If there's anyone else, if there's co-authors or anyone, you can go ahead and give those details as well. What kind of work is it? Is it literary, dramatic, artistic, all those kinds of works? The title of that work, that will all be in the statement of particulars. In the step 3, you have statement of further particulars. Further particulars is just talks about what the work is. If you have any translations of that work, any adaptations of that work, all those details, whatever you have for that work, will come in the statement of further details. And your last step is the payment details, which is just go ahead and pay for the application. Now once all of these steps are done, everything is done, you have to go back, and you can see on this side there's an upload work and documents. Now this is where, after all of those 4 steps are done, you're going to go back and upload your work, your artistic work, literary work, all kinds of work that you have, anything that you have for that application will be uploaded over here with the power of attorney, if you are obviously using a legal representative to help you out. And that's how your copyright application will be done. It's all filed. And your last step is also to take out the receipt, all the details that you have this form, and you have to post it to the New Delhi office of the copyrights, and that's when your final application reaches them and will be scrutinized further. Coming back over here, we'll move on to the conclusion. Now the conclusion here, the main thing that we have learned, I think all of us today, is why is it important to protect your copyright. Right now, especially in this day and age, we are all digital. Everyone is using the digital space. We are consuming a lot of content. We are also creating content. We are consuming it at the same time. So it's you have to have a balance between the two. Whatever we are making, whatever we are putting our blood and sweat to, you have to protect that creation. And that's why it is very, very important to protect all forms of protection. Another one important thing why you have to go ahead and protect and actually register your copyright is to have a legal ground. If I don't have a registered work, if my painting that I drew, the sunflower painting that I drew, did not have a actual copyright protection or registration, I wouldn't be able to have a strong enough legal ground to go ahead and sue anyone who has infringed on my right. So to have that right for you, you are the one who has to safeguard your side of the story, and you are the one who has to get all of that protection. So go ahead and get it registered. That's very, very important. And lastly, crediting. I mean, even if you're taking a small inspiration, if you're taking a small line, word, sentence, anything that you're taking from anywhere, even if it's fair dealing for that matter, always credit the source. Always tell who you are taking it from, and that's how you will be able to create. That will be a good and safe space for every type of creator that is out there. And I think that's about it. We have, as we had promised, a few little takeaways from this little webinar is, if after this you are motivated as a creator or any other kind of person, if you're motivated to go ahead and register your copyright, we are here to give a free consultation. You can come up, approach us. We have all our details mentioned over here. Approach us and we'll be happy to connect, happy to engage with you guys. And lastly, a little takeaway after this whole seminar, webinar on copyright, we have one little question. If you guys could come back to us again with the answer of it, will be great. We know that we were successful in the webinar today. There's a very famous application called Pinterest, and it's a lot of work that is uploaded, and a lot of kind of pictures, a lot of information for that matter is also available on Pinterest. What, according to you, is Pinterest? Is it a stock photo resource, or what is it? So do come back to us, and we'll be waiting for some replies and
Yeah.
some engagement from all of you guys.
And just to add to the free consultation part of it, even if you guys have any questions with respect to, let's see, we'll address a couple, but
Yeah.
if we can't address your question and it's really important to you, you can always drop us an email. We'd be happy to give you a consultation on when and why and how should you protect a copyright, or if you have an existing copyright.
Yes.
We understand intellectual property rights is not right now that developed in India, so we would be happy to help you on any sorts of help with respect to intellectual
all
property.
forms of intellectual property, not just copyright, patents, trademarks, anything. You can definitely reach out to us. Again, I'll just go back and show you if you want. Just take down the email. You can visit our website. You can get a lot of details from there as well.
Yes.
And
we'll address a couple of questions.
Yeah, we'll check a few questions if we can and address them. How can Indian universities have, especially in India, like we've seen a lot of, especially engineering universities, of all kinds of universities for that matter, they have a good amount of content that they have good amount of research papers, PhD scholars, they have a lot of good work that is usually available online, and people take it. Even if you cite it, even if you credit it, it's very, very important. If you've spent, say, a year or two in the research of that, it's important for you to just safeguard it for your sake. You need to get, and it's obviously later on you can go ahead license. There's so many things in copyrights which we can't discuss in this short duration of 1 hour, but it can be an alternate revenue stream also for you guys. So that's why register.
Yeah, I mean, just to add to this, I feel Indian universities and why copyright is important to them is Indian universities is the ground for the most amazing research papers and, let's say, kind of articles and the kind of thesis and all of these works that go into picture. Students really put their heart to it because that's genuine interest and passion coming, right? And you just, by the end of it just becomes an assignment by the end of it. Why not register it as a work? Maybe it'll help you to give conferences outside India. People get that much attention, your work will get that much attention, and if you try and market it later, you'll be protected on that ground. So I mean, as universities in India which are constantly going towards a landscape where education is more practical and skill based, I think copyright is a concept that should definitely treated as a very vital skill, because legal help you'll find lawyers, but you yourself need to understand the kinds of concepts that go around intellectual property rights, right?
I feel like even businesses, the first lawyer that you might need, the first legal help in general that you might need to start a business or anything, it is intellectual property. You would want to protect the name of your brand by trademarks. You have so many, as Yesheshvini gave examples, business proposals, even this PPT for that matter. We really put our efforts into making a PPT. So those are the little things that you need to understand, that yes, these are worth that protection. These are worth, people might just go ahead and copy those, but we need to do it from our sides, give that assurance to ourselves that yes, if we protect it, it will be great for us.
Yeah, I think next question we can take tap for life online.
Which one?
Photograph taken in public with some advertisement in background is infringement.
Photograph taken online, even if you take a photograph, but again, if you are using that advertisement, if you are focusing more on that advertisement, that is when actual infringement will come into picture. If it's again intention and motive, as we discussed here earlier, if intention and motive is not there to actually go ahead and take that advertisement and infringe on that, then it won't be an infringement. Anything else that you can take?
Let's talk about, I think, check the license option. Will it lead? So using images from Google for PPTs for online education, I think Ms. Rashmita Sahu asked us this. It will not lead to infringement per se, because you're using it for educational purposes and to educate your students. Obviously, if it's something relating to profit making, it might lead to infringement, but per se using it for education is good enough. If you still want that kind of security, as Shravani explained in, like, I think the 30-35 minute bracket of the webinar, use the Creative Commons license as your feature in Google when you try and select images. That will help you, obviously, if just in case we find a creator who's very possessive about his work, that should help you.
Can copywriting usage rights prevent the artwork being used? Yes, usage rights actually do protect a lot of, as you've mentioned, commercial licenses. If I go ahead and put an artwork of mine on the Creative Commons website and give a license out, so it depends on me as a creator, which is why Creative Commons is such a great platform. Is for me, it's free to go ahead and upload my artwork and actually put down a license and the terms and conditions that I want for that license. So if I want that license to be free for everyone, if I want people can use it freely, then I can put that down in the Creative Commons website. But if I want that, okay, this is my artwork and I don't want people to be freely using it, then I will put it under the commercial licenses part.
Can you use an image having a copyright as reference or example in a research paper or thesis?
Yes, if you want to use a research paper, a photo, I think you've mentioned a photo.
Yeah.
An image for your research paper, then that won't be amounting to copyright. But again, even then, always credit the source.
Yeah.
Citing, just putting down who you took it from, that inspiration, very, very important. And just goes to say that you respect someone else's artwork also.
Yeah, so it's just that if your kind of, let's say, image is used by somebody without crediting you, you would really feel betrayed. Yeah. So it's better if we, as a society, we start encouraging the fact that you need to credit, you need to, put the source down.
Yeah. I mean, sometimes it's flattering for artists to, if someone copies your work, but again, that's really, it will go just so far. It won't be as much, because you are, at the end of the day, if you go ahead and get profit out of it, that is just unfair.
With respect to the Form 14 question, column 2, who is the other concerned parties? Is it the author themselves?
The other concerned parties in the work would be anyone who is even remotely associated with the work. So if I have written down a book, or Yesheshvini, as she said, has written down a book, and I just contributed half a paragraph in that, or even one paragraph in that, my name will also be mentioned as a concerned party, because I have also contributed to that work.
Our professor from our college is here, who's also helping us answer questions.
Yeah.
Thank you,
Professor.
Okay, so there's a couple of questions about patents. I feel that you can email us. Let's try and concentrate on copyrights right now. What is the best way of publishing a research paper in a journal and register it for copyright, or copyright first and then communicate?
No, you can. There's nothing about copyright that has to be that if it's in the public domain, it won't get registered. If you have a research paper that is already published, even then you can go ahead and get it registered, get it protected under copyright. So there's no first thing.
Tata Capital's signature tune can also be used as a trademark. Again, anything except copyright wouldn't be good to be addressed today. So I think let's
that's it.
Yeah, no? I think that's about it. Research paper can be registered as copyrights. Mathematics formula can be registered as copyright as long as
they're new. They're an original. You can't already a square plus b square. Those formulas you can't go ahead and copyright. Yeah. If it's a new one that you've actually created by yourself, then you can go ahead and copyright that.
So basically, to sum it up, copyrights are important, although heavily overlooked. It is something you should take for the works we have mentioned. If your work does come under that category, and if you know somebody whose work comes under that category, it's again important to make sure creativity thrives in the society we are living in, and we need to ensure this by making sure that legal in here. And if you do want to contact us, again, you have our email IDs. Go through our website and please register your copyright. It's important, if not with us, with somebody else, but make sure the hard work of your blood, sweat, labor, it's protected, it's important. And I think that's about it. I think we'll just take one last question before we sum it up.
Yes, when Zoom was replicated, it was an exact replica. It was not like there was even here and there different kinds of interface. The interface was taken as it is, and Zoom did go ahead and actually get back to them. So yes, that was the same.
again, a lot of questions about images being used on public platforms, and you using it. Please try and credit the source, or please just use the Creative Commons license.
Yeah.
Because anything
Always
else,
safe.
yeah, beyond that, you never know who's on the other side and wanting to, the kind of work they have put in, let's say, a photograph or a research paper or whatever it is. So try and make sure you adhere to those guidelines, and I think you'd be fine. Again, we have stated the kind of things, education, let's say news, journalism, you can use these
Yeah.
images freely. There is a right to copy, you have even in copyright.
Yeah.
So just make sure you always be on the safer side of things and do not infringe somebody's hard work.
And even when you go ahead and do not filter the usage rights, if someone has a commercial license and you have used their image, they will get to know if you've used that image, if you are obviously using it in an unauthorized way. So that's why always just go through it. It's a very simple step and you'll be free.
Yeah.
You don't have to worry about any infringements, any costs,
Yeah.
and all of those things.
Yeah, I think that's about it
That's
from
about it.
us.
Yeah.
And
Hope you guys enjoyed this.
yeah, we
and
hope you enjoyed it, and hope you take the takeaway and the activity seriously.
Yes,
And
we'd
yeah.
like to also thank Turn IP and Mr.
Yeah.
Rahul for
Yeah.
conducting this webinar for us. We are really happy that we got to do this,
Yeah.
and hope that we get to do more
More
such
such things.
webinars on different types of IPs, maybe.
And we appreciate all of your attendance. As mentioned in the last slide, your certificates would be issued on Monday.
Yes.
Thank you so much for tuning
Thank
in
you.
with us. Thank you.